Okay, I think we're live. So I will begin this public hearing. Good morning. My name is Julie Kushner. I'm state senator from the 24th district, covering Sherman, New Fairfield, part of Bethel, and Danbury. And I am co-chair of the Labor Committee and vice chair in Public Health. And I want to thank everyone for being here today for this informational hearing on the issue of smoking in our casinos. I will keep my remarks brief. I know that when we planned this session, we had hoped to go to noon, but given that the House is going into session at 11, we have asked folks to be brief so that we can get through the panelists and have a Q&A at the end. I will just say that this is...
What?
Is the guy from the area or?
And I'll ask Devin to, thank you, mute our committee members. This issue has come before the General Assembly before, both in 2003 and in 2008 and 9. And the issue of smoking in the casinos, I think, has become more timely now that we have experienced this public health crisis. And in this public health crisis, we've learned that people are vulnerable, and therefore smoking was voluntarily stopped in the casinos during this time. And we applaud the tribal nations for taking that step to protect the public and to protect the workforce. But we are concerned that after the public health crisis hopefully comes to an end, hopefully soon, we are concerned that it would continue. So with that, I will ask for other remarks by our chairs. I see Representative Jonathan Seinberg, chair of the Public Health Committee. Would you like to make brief remarks?
Good morning. Thank you for putting this together, Senator Kushner and others who have been involved in today's informational forum. This is indeed an important opportunity for us to talk about something that is very important here in the state of Connecticut. We're very aware of our extremely high asthma rates, our extremely high respiratory disease rates. And while we as a legislature have been very proud to have passed the Tobacco 21 bill a couple of years ago and are currently working on additional legislation related to flavored products, we know that there are still pockets out there which are really still problematic. And I'm sure we're all going to learn today about just how urgent that need is. So thank you for putting this together, Senator, and I look forward to hearing more.
Thank you. And I recognize my wonderful co-chair of Labor, Representative Porter.
Thank you, Senator Kushner, and I will be all ears. This is new to me. I've been brought up to speed by yourself and others that I've had an opportunity to speak to about the matter of banning smoking in casinos. So I'm very interested to hear from both sides, where we stand with this and where we plan on going in the future, and definitely with a focus on workers and what's going to be best for them and the casinos as a whole. So thank you, and let's get started.
Great. And I will ask if our ranking members would like to make any brief comments. I see Representative Aurora there.
Thank you, Senator Kushner. This is such an important issue. I'll just give a very short anecdote. I was traveling with my son last year, or the year before. Last year there was no travel and we stopped on a road trip across America in Vegas. And my son remarked, "Dad, why do they allow smoking here? I don't want to go inside to watch the show." And I'm like, "Yeah, you're right. Maybe we should be thinking about it." And then a couple of days ago, last week, I hear about this informational hearing. So I'm very glad that we are hearing on this issue. I think it's an important issue, as my son pointed out, as my 12-year-old son pointed out. And I will be listening in with full attention, although I'll be on audio only. Thank you very much, Senator Kushner, for organizing this.
Thank you. And at this time, I don't see any more of our ranking members. If I'm incorrect about that, Jonathan, please help me with the Public Health Committee. But I think that's the case. So I think we should begin.
Excuse me, Senator, Representative Pettit will be on in just 1 second.
Okay, great. Then let's give him that second, because I would like to give him the opportunity to comment. In the meantime, I know everyone is anxious about the House session starting, and we have reworked the agenda to hopefully give everyone, all the panelists, an opportunity to speak. And we will be holding our questions until the end. And I will ask for expedience of time and for the ability for as many members to have an opportunity to ask the question, that we restrict the question to one question per committee member. If we have time, we can then do a second round. In asking your questions, I would just encourage you to be brief so that we have more time to hear from the panelists. And with that, I see that Representative Pettit has joined us, and the chairs and ranking members have already made opening remarks, but I would like to give you the opportunity to remark briefly on this informational hearing.
Thank you, Madam Chair. I'm here mostly to listen to the sides of the issue and gain a little clearer understanding of what the major issues are at play. So I'll hold it at that and let the people with the information speak. Thank you.
Thank you very much. So with that, we will begin with our panelists, item 3 on the agenda. And we will be starting with the Mashantucket Pequot Tribal Nation. And I have the honor of recognizing our first panelist, Chairman Rodney Butler. And I have to say a few words because my relationship with Chairman Butler goes back many years. And we were in a situation where in other labor negotiations, things might break down and relationships might get hostile. But I have to say how much I respect Chairman Butler, because your relationship and your guidance through the negotiations we had with you were exemplary. And I feel so proud that we were able to craft not only a good relationship, but a friendship. And so it's a pleasure to see you here today. And with that, I would ask you to begin your remarks.
Well, thank you for those kind words, Julie. I always appreciate the friendship first. And, you know, as we always say, we're all on the same team here. So, Kubi-Kwasa and Natapawant, good morning, friends and distinguished members of the Health and Labor and Public Employees Committees. As Julie noted, my name is Rodney Butler. I'm chairman of the Mashantucket Pequot Tribal Nation. I'd like to make a few brief opening remarks this morning, and then I'll turn it over to a longtime friend and counsel, Kane Smith, from the law firm of Drummond Woodson, who is an expert on all matters of tribal sovereignty, to answer any specific questions as I have to jump off to a council meeting. I'm going to begin my comments today with a statement known as a land acknowledgement. It has become customary across Indian country to formally recognize the relationship between Indigenous peoples and their traditional territories at the outset of any public meeting, a means of respecting the historical context that has brought us to this point in time. Connecticut's present-day nomenclature is filled with Algonquin words, as we all know, and traditions, including the name of the state itself, which means the long tidal river in our native Algonquin language. I'd like to acknowledge as well the great work of this General Assembly in raising awareness and passing policy with a laser focus on addressing the racial inequalities and social injustices of our past. It all ties into this conversation today, and the tragic and abhorrent acts of aggression against people of color and other minorities have brought to the forefront of debate what we have experienced for time immemorial here in Connecticut. Connecticut leaders and many others should be commended for challenging the systems to change. The issue before us all today, while no doubt well-intended, speaks directly to the heart of Native American rights and tribal sovereignty. Debating what the laws should or shouldn't be for a sovereign territory, I contend is no different than this legislature debating what laws you should enact for Rhode Island or New York. Yet the confrontation with tribal sovereignty continues in that sense. From a health and wellness perspective, we are incredibly proud of our commitment to the health and well-being of our family and team members here at Mashantucket. Our own family members work in the casinos. In fact, we're enormously proud of the fact that we just announced Jason Guyette as our first tribal CEO. So again, public health, the health of our family and team members is of utmost importance to us. To further highlight that point, throughout the recent pandemic, and I agree with you, Julie, hopefully it ends sooner rather than later, we regularly maintain COVID safety guidelines that exceeded those of the state. In addition, and as an extension of our sovereign authority, we took the unprecedented steps to make vaccines available to our entire community, including our team members, well in advance of them being eligible in their own state. So in short, we welcome any discussion as it relates to health, as is one of our core principles in our mission statement, along with protecting our sovereign rights. But we can't support the state of Connecticut acting in a manner that is disrespectful or contrary to tribal sovereignty and our government-to-government relationship. And we ask that you consider that in any proposals that move in contrary to that direction. So again, Uaw Region, thank you and be well. And I appreciate your time. And it's great to see all my dear friends this morning once again. And again, keep up the great work this session. And so with that, I'll turn it over to my good friend and colleague, Kane Smith, who will provide his testimony on sovereignty. Thank you again.
Thank you, Rodney.
Thank you very much, Mr. Chairman. Hopefully you can all hear me. Can you hear me?
Yes, we can.
Terrific. Senator Kushner, Representative Porter, Senator Abrams, Representative Steinberg, and members of the Labor and Public Health Committee. I'm delighted to be here today. My law firm, Drummond Woodsum, has represented the Mashantucket Pequot Tribal Nation for decades. I'll just say at the outset, I'm sitting at Logan Airport. Hopefully you won't hear the speakers too much around me. I'm bound for the Northwest and have to be out of here by 11. So if we don't get to all of your questions for me, I'd be happy to submit written responses after the session. So I've been asked, let me just say briefly about our firm. We represent tribal nations across the United States. I am an attorney representing tribal nations and enterprises in mostly litigation matters in the tribal, state, and federal courts. I'm currently on partial leave from my firm, Drummond Woodsum, to serve as the Distinguished Practitioner in Residence at Cornell Law School, where I teach a course entitled Law and Colonization in Indian Country. I am the author of a treatise, Labor and Employment Law in Indian Country, published by the Native American Rights Fund. And I am currently honored to be a part of the American Law Institute's drafting of the restatement of the Law of American Indians. I'm an associate reporter on that project. We expect it to be approved later this year. The Mashantucket Pequot Tribal Nation, which I will refer to as the Nation, has asked me to place the subject of a potential bill to ban smoking in public places in the larger context of federal Indian law and tribal sovereignty in general, but also in the context of tribal state relations between the nation and Connecticut in particular. And from that process, there are two tools that immediately derive. The first is diplomacy, the relationship between two sovereigns for resolving issues of concern to the sovereigns. And the second is, in light of that, respect for tribal sovereignty and the tools that are in place at the Mashantucket Pequot Tribal Nation through their own laws, and that in particular is collective bargaining. We're actually somewhat surprised at this interest in passing a bill for the purpose of it seemingly forcing something upon the nation when there's a tool immediately in place, which is collective bargaining to address the terms and conditions of employment. And obviously smoking would fall directly into that. And that's an ongoing process. Let me just say that the default should not be confrontation. The default should be diplomacy and respect, mutual respect between sovereigns. Those are the lessons that fall immediately out from federal Indian law and the history of tribal relations across the country. I'll briefly, in terms of the context for federal Indian law, say that Indian tribes, as I think you all know, are governments. So many people don't understand the nature of tribes as nations. They are governments. And the Supreme Court has clarified that they possess the inherent sovereign authority of any government, unless and until it is taken away by Congress under its powers under the Constitution, because Congress has, pursuant to the Constitution, what's known as plenary authority over Indian affairs. And these powers are not granted, they're inherent. Indian tribes possess all attributes that any government possesses unless and until they are taken away, just the same kinds of powers as states. So like states, tribes have the inherent power to engage in economic activities and to regulate those economic activities like lotteries and liquor stores, some do, for the purpose of generating governmental revenue. Unfortunately, tribes don't have tax bases, so they derive governmental revenue through things like gaming, tourism, timber harvesting, and those sorts of things. The United States, as I said, is the sovereign out of the three. We'll get to the three sovereigns in a minute, that has the plenary authority to control Indian affairs. And it's so pervasive, according to the Supreme Court, that Congress can even breach its own treaties, so long as it does so clearly. But Congress has sort of gone through various phases in terms of federal Indian policy. And right now, Congress is like from termination, literally termination, the annihilation of tribes, the so-called Indian problem as the colonization process took place. But right now, and we hope that this continues forever, Congress has a commitment to tribal self-determination and sovereignty. And that is what is at stake here. And I'll just say briefly that absent a grant from Congress, states have no authority in Indian country. States have no authority to impose their laws upon tribes in Indian country. The great French observer of American democracy, Alexis de Tocqueville, once observed in the middle of the 19th century, and I'll quote, "The conduct of the United States Americans towards the natives was inspired by the most chaste affection for legal formalities. The Spaniards, by unparalleled atrocities, which brand them with indelible shame, did not succeed in exterminating the Indian race and could not even prevent them from sharing their rights. The United States Americans have attained both these results with wonderful ease, quietly, legally, philanthropically. It is impossible to destroy men with more respect for the laws of humanity." This is an extraordinary observation from the detached French observer, the great de Tocqueville, who is known for his book, of course, Democracy in America, explaining what goes on in the colonization process. And it is, in a word, brutal. And the United States has been through phases of Indian policy, from removing tribes from the eastern seaboard out west to Oklahoma, to trying to assimilate tribes into the great melting pot, which was disastrous, to actual termination. And from the 1970s to the present, Congress has embraced tribal self-determination and has encouraged the kind of economic development that you see exemplified by Foxwoods and the terrific tribal state relations that have flowed from that in the order of $8 billion annually to the coffers of the state of Connecticut. Let me just now shift to tribal state diplomacy. Sandra Day O'Connor once wrote that there are, quote, 3 types of sovereign entities: the federal government, the states, and Indian tribes. Each of these 3 sovereigns has its own judicial system, and each plays an important role in the administration of justice in this country. So the tribes are the third sovereign. And in the modern era of tribal self-determination, tribes have thrived. And it's well exemplified by the thriving tribal state relationship here in Connecticut. One of the most significant economic forces, of course, in the state of Connecticut is Foxwoods and the gaming revenues that generate for the state. And the nation proudly exercises its inherent sovereign authority in that process. The smoking ban to be imposed upon the nation through the enactment of state law may seem to be a small thing, but in the scope of the foregoing context and history of federal Indian law and tribal state relations, it is not. So confrontation, again, should be avoided and mutual respect embraced. In 2008 and 2009, as Senator Kushner mentioned, there was discussion about these issues. They were resolved through a respectful give and take between the state and the tribe. That is the default position. Confrontation should be avoided. Diplomacy should be enhanced. Now let me shift to the respect for tribal sovereignty that is literally due here, given this context. And that is respect for the laws of the Mashantucket Pequot Tribal Nation. The nation has exercised its inherent sovereign authority to enact its own labor law, 32 MPTI. And pursuant to that law, the nation's gaming enterprises engages in collective bargaining to resolve asserted prohibited practices. It, of course, engages in the bargaining process to develop collective bargaining agreements to address the terms and conditions of employment at Foxwoods. And this is a tool, and it really should be the tool that is advanced here. It makes no sense and is very confrontational for the state of Connecticut to presume to enact its own law and pull a fast one, frankly, when there is an immediate tool in place pursuant to the tribe's own sovereignty to allow a give and take between the workers and management to come to an agreement on this issue. We all want public health and safety. As Chairman Butler said, there are members of the tribe on the ground, family members on the ground at Foxwoods. And through this process in the past, we will just say, through the process of diplomacy, the tribal respect for tribal state relations, and the collective bargaining agreement, there are air quality standards that are in place that the tribe is quite proud of. And I believe the union is quite proud of as well. And this is the result of the tools at stake that should be used: diplomacy and collective bargaining. Foxwoods conducts air quality testing semi-annual by independent accredited air quality experts. As the nation agreed with Governor Rell in 2009, this air quality testing satisfies the collective bargaining agreements with the UAW. There's a collective bargaining agreement currently in the works. If these issues need to be aired, so to speak, they should be aired in that context. Thank you very much for this opportunity. I would welcome questions. As I said, if we run out of time, we would be delighted to submit them in writing.
Thank you, Attorney. I'm sorry, Smith. A hard name to remember. I apologize. Thank you, Attorney Smith. And as we mentioned, we will have questions at the close, and we hope to get to them before 11 when you have to depart. But I appreciate your willingness to answer in writing, and I would ask all the panelists to be prepared to do that. Next up, we have from representing the Mohegan Tribe, Attorney B. Heather Sibison, and she's an attorney with Denton's. And do we have you here? There you. I'm looking to see. Devin, do we have Attorney Sibison with us?
Yes, Madam Chair, we have Attorney Sibison.
Okay, I would ask that you turn on your camera and unmute yourself so we can see you.
Good morning, everyone. It is not allowed. Oh, there it goes. Sorry, it's just popping up now. Thank you for your patience.
Sure, thank you.
Sorry about
Good.
that.
We can hear now. We can hear.
Terrific. Thank you, Chairwoman. Well, good morning, everyone. And in particular, good morning, Chairwoman Kushner and Porter, Chair Steinberg and Abrams, and honorable members of the Public Health and Labor and Public Employee Committees. My name is Heather Sibison. I am appearing today to provide the testimony of the Mohegan Tribe. I have practiced federal Indian law and been involved in federal Indian policy for about 30 years, some of which was during my service working on Native American issues in the Clinton administration at the U.S. Department of the Interior and at the U.S. Department of Justice. I'm a partner at the law firm of Denton's U.S. LLP, and I serve as the chair of our Native American law and policy practice. I have had the honor to work with the Mohegan tribe for more than a decade, and I'm honored to have the opportunity to speak before you today. I think it is important to start my remarks with a brief discussion about the tribe's history because I think it is relevant to the issues being discussed today. As the U.S. Senate Committee on Indian Affairs has written, the Mohegan tribe is descended from one of the most powerful and historically significant American Indian tribes residing in New England at the time of the first European settlement. While the Mohegan people had positive relationships with Connecticut's earliest colonists, as former Senator Chris Dodd so well put it, but regrettably, in a scenario that has become all too familiar in the annals of the history of the United States Native American relations, the Mohegans ultimately paid a severe price for their willingness to cooperate. They were eventually forced onto a reservation, only to find the boundaries of that land shrink steadily over time. In 1705, the colony of Connecticut was rebuked by a royal commission for infringing upon the tribe's 2,000-acre reservation of land west of the Thames between New London and Norwich. Nevertheless, white settlers continued to encroach on Mohegan lands, and by 1846, the state of Connecticut had whittled the tribe down to only 2,300 acres, about 1/10 of its original reservation. In 1861, the tribe's status was terminated. The state subsequently turned the tribe's capital into a state park and distributed most of what was left of the tribe's land to private landowners. By the 20th century, all that remained in tribal ownership was the tribe's church. The legality of these land grabs was dubious at best, uncontrovertibly illegal at worst. As the Senate Indian Affairs Committee noted, the state of Connecticut never received federal approval for any of those conveyances which diminished Mohegan Indian ownership of tribal land in accordance with the requirements of the Federal Indian Non-Intercourse Act. For more than 150 years, Connecticut made various commitments to respect the tribe's right to self-government and the tribe's sovereignty over its lands. But each of those commitments in turn was broken, and the tribe was left with nearly nothing, most disastrously, with no land base over which to exercise its fundamental right of self-government. In 1977, the tribe sued Connecticut regarding the thousands of acres of land that had been illegally stripped from the tribe. To the state's credit, it worked with the tribe to fashion a settlement that would help restore the tribe's ability to exercise its sovereign right of self-government. In other words, as the Senate Indian Affairs Committee highlighted, the tribe gave up, quote, very substantial and valuable claims, not for a cash settlement, but for the right to establish a federal Indian reservation and to engage in economic development activities there. Only with land could the tribe, and can any tribe, fully enjoy the rights and privileges of self-government inherent in the exercise of governmental sovereignty. While the settlement land, which comprises the tribe's reservation today, is but a tiny fraction of its territory, the fundamental importance of the tribe's right of self-government on that land cannot be overstated. And the respect for that right must be understood as part of Connecticut's and the United States' efforts to address egregious historical perpetrated against the tribe. The Mohegan tribe has a long history of working cooperatively with the state of Connecticut and with its neighbors in the surrounding community. It deeply values those relationships and works hard to keep them collegial and productive. The tribe's concern for the health and safety of its members, of its neighbors, and of the guests who visit the tribe's businesses is genuine and has long been borne out by the tribe's own internal rules and regulations. At Mohegan Sun, the tribe has long prohibited smoking in common areas and restaurants and provides non-smoking areas on its gaming floor such that approximately 90% of the entire facility is non-smoking. Employees who wish to work in non-smoking sections of the gaming floor are entitled to do so. And since the COVID-19 pandemic erupted, the tribe has restricted all smoking to limited designated outdoor areas. The tribe's air handling system is among the most sophisticated in the United States. State-of-the-art cleaning equipment exchanges air up to 25 times an hour, whereas conventional building HVAC systems only exchange air at a rate of 3 times an hour. The Mohegan Sun system utilizes technologically advanced air filters and particulate conditioning systems that further enhance the air filtration process. The tribe system regularly monitors air quality and automatically adjusts ventilation to maximize the effectiveness of the system. The tribe's record of working in concert with the state to address potential exposure to secondhand smoke is well documented. After government discussions in 2008 and 2009, the tribe adopted more stringent standards. The tribe's new operational requirements were memorialized in agreement with then Governor Rowell and incorporated into the standards of operation and maintenance that are part of the Tribal State Gaming Compact that embodies the mutual agreement of the state and the tribe on issues like this. While the tribe implemented these measures in consultation with the state, I do want to underscore that ultimately decisions about the standards by which businesses will operate on the tribe's reservation are and should be the tribe's decision alone to make. When these standards are incorporated into the tribe's agreement with the state, it is because the tribe has chosen to enter into such an agreement. Former Attorney General Richard Blumenthal strongly supported adoption of the smoking ban by the Connecticut State Legislature, and he testified to that effect. But in that testimony, he also acknowledged that, as a matter of law, public places on reservations belong to federally recognized tribes. Places on reservations belonging to federally recognized tribes have a different status under federal law and principles of tribal sovereignty. The tribe respects the Connecticut State Legislature's authority and right to enact the civil codes it deems necessary for application within the state's jurisdiction. The tribe is eager to continue the productive dialogue it has always had with the state about these kinds of issues. And for that reason, it appreciates very much the opportunity you have given it today to present these remarks and to continue the discussion. But the tribe also respectfully reminds the state that in the 21st century, attempts to whittle away the tribe's sovereignty must come to an end. The tribe asks that you give to the tribe the full measure of respect that sovereign governments owe one another, as the tribe has given that respect to the state. Again, I appreciate very much your time today, and I'm happy to answer any questions that I am able. Thank you.
Thank you, Attorney Smith. I know that you're not able to stay with us until 11. I would ask that members of the committee who have questions for Attorney Smith that you submit them to our clerk in writing, and we will get them to you. Unfortunately, we had hoped to have a back and forth. However, with the House going into session, we find our time very limited today. But I appreciate you being here today, and we will certainly take your testimony into consideration in our deliberations. Thank you very much.
Thank you, Madam Chairwoman. Thank you.
And next up, we will hear from item number C on a panelist. We're going to start with the UAW Regional Director for UAW Region 9A, Beverly Brakeman. Are you with us?
Yep.
There you go.
Hi, everyone. Hey. Good morning, Senator Kushner, Representative Porter, Senator Abrams, and Representative Steinberg, and members of the Public Health and Labor Committees. I want to thank you for holding this hearing today. I'm the director of UAW Region 9A. As you might know, we represent approximately 600 to 700 post-pandemic members or dealers at Foxwoods Resort and Casino. And I'm here to talk a little bit about the history of our work to ban smoking in the state's casinos. Before I do that, I thought that I'd like everybody to just take a minute, shut your eyes if you want, but imagine that rather than this morning coming to your desk and sitting in front of your Zoom computer mirror or going to the office, you had to drive and walk into your place of work and stand behind a table, only to have people sitting there playing cards, enjoying themselves and smoking cigarettes in your face. Imagine having to go into that every single day. I can't imagine it. I wouldn't want my child to have to do that. And I wouldn't want any of my friends to have to do that. And that's what the casino dealers at Foxwoods have to do every day. And the beverage and food servers as well. You know, there's not a whole lot of good things you can say about this pandemic, but one thing that has come out of it is that both casinos on their own have agreed to be smoke-free. And it is a whole different world for our workers. And you're going to hear more about that from some of the other panelists. But I want to make that point to you because I think we take for granted the fact that we go into a place of employment where we're not going to walk out smelling bad, feeling bad, and having to take a shower the minute we walk out. And that is not the case for dealers and workers at Foxwoods and Mohegan Sun. There are essentially three arguments you're going to hear, I think, today against banning smoking in the casinos. And I'm not going to go into depth on them because we have experts here today that will. One of them is the issue of state jurisdiction to impose a smoking ban on the casinos. And we have an attorney that will talk about our ability to do that. Both tribes in their agreements with the state have agreed to uphold public health standards, at least as rigorous as the state's public health laws. Given that since 2003, secondhand smoke has been prohibited in most restaurants and bars, I would say this is a quintessential public health law that should be followed under the agreements with the state. Additionally, because of the way the smoking ban is applied through the state liquor license, both tribes do have a state-issued liquor license. In terms of losing revenue, you'll hear a lot about that. There's not a lot of studies that have been done on that, but there are a number that show, in fact, those fears are not true. If you look back to when we banned smoking in this state, the restaurants were incredibly fearful they would go out of business and go broke, and that did not come true. Just some facts that might be helpful. More than 1,000 gambling venues across the U.S. have either opened with or transitioned to 100% indoor smoke-free indoor air policy. Smoke-free air is already a normal part of casino entertainment and job experience in many markets. 20 states require all commercial state-regulated gaming facilities to be smoke-free indoors, plus the U.S. Virgin Islands and Puerto Rico. In Delaware in 2005, when they went smoke-free, they didn't see any decrease in their revenue. 4 out of 5 gamblers are non-smokers. In July of 2008, a study was done that showed 85% of gaming customers would prefer to go to a non-smoking venue. And then the other argument you may hear is that gamers will go to other states. And I think we should have more faith in Connecticut's gamers to be loyal to our 2 states' casinos, who are incredible employers and provide incredible entertainment for Connecticut's residents. I think there's a lot of loyalty there. At this point, what's different than when we passed this bill in 2010 in the state Senate, only one state borders Connecticut that actually allows smoking in casinos, and that is Rhode Island. The other state that people could go to is New Jersey. So that argument isn't as strong as it used to be. So I'm going to leave it there because you have a lot of other people who are going to testify much more expertly than I am. But I would ask all of you, thank you again, and urge you all to strongly consider doing this or finding a way to have our state's 2 casinos go smoke-free and protect its workers. We're open to any and all avenues on how to get that done. Thank you.
Thank you. And next we have Andy Comey, who is an industrial hygienist with the UAW International Union. Is Andy with us now?
Yes, I'm here.
Good to see you, Andy. Good morning.
I had a few slides to share. Do I do that on my own?
Devin, can you arrange for Andy to have the ability to share his screen?
Yes, Andy, you should have that ability now.
Great. Go ahead.
So I just wanted to take a few minutes to share some of the history of the collective bargaining agreement and how it relates to ventilation and reducing exposure to secondhand smoke in a casino. I was involved in negotiations, developing contract language, participating in some of the arbitration hearings, and then helping to set up some of the sampling protocol. So what you see here, there's a slide that shows one of the large gaming floors. This is the Great Cedar gaming floor. A lot of what you see there are slot machines. In the upper right-hand corner, there's a section that they call Pit 10. Somewhere around P3, if you look at the grid. There's a series of tables, what they call the gaming tables, where blackjack, card games, roulette, that's where our dealers would stand. So that's sort of the seating arrangement. And again, all of the other, most of the other equipment you see there are slot machines. So that red square is the area of Pit 10. So I wanted to just focus, we have 2011 to 2021 data. At each, those green dots are locations where we've developed an air sampling plan. A set of third-party experts have come in for the last 10 years and taken samples twice yearly. So we have some really good data on what people are potentially exposed to in those areas. So we have some contract language that spells that out. I don't have time to go into the contract language, and that's all published on the UAW website. One of the important lessons we found out, there's this idea of particulate matter, PM 2.5. For the most part, the PM particulate matter that we think about with cigarette smoke is in the one microgram diameter. So it's a significant in terms of when we talk about filtration. This is the kind of equipment they use. So the third party puts air samplers on a small cart and pushes it across the floor and takes samples. And again, here's the sampling grid. They take at each green dot, they'll take a 1-minute sample. They're sampling for carbon monoxide, carbon dioxide, oxygen, particulate matter, and the mass of particulates. So again, they're doing that a couple times each year. We try to spread it out so that different seasons are covered, different days of the week, different times. They're looking at both the no smoking areas and the smoking areas. And this is the kind of map we were dealing with. So this is from 2011, June, and the levels are very high. So this grid is taken, and with a GIS system, that third party determines what the smoking levels are in different parts of the casino. So ostensibly this Pit 10, again, that area that we talked about, you can see it's yellow, which is lower levels, but you can see that it's being, there's smoke from the surrounding slot machines coming into that area. So the workers were concerned about this. They did have high exposures and irritation. We compare, and again, we did the same grids for each of the gaming floors. And this gives you an example of some of those levels that James Rapace will be talking about in different areas. You'll note that there's still the mean exposure, even in the poker room. If you look at that graph along the bottom axis, poker room is no smoking, and yet people are still exposed at the 70 microgram level, which is significant. So these initial studies tell us a lot about the inadequacy of ventilation. There's a difficulty with the poker room, for instance, was located in an area where doors could open. There was an architectural cutout where smoke could drift into the area. And it was difficult to control, even in smoke in the no smoking areas. And again, I talked about that 1 micron level for particulates, that 1 micron size. If you think about MERV filters, there's a lot of stuff in the news about MERV filters with COVID, controlling SARS. At the 1 micron level, the MERV 11 filters in place at the casino were virtually useless, had zero efficiency in removing cigarette smoke. So again, we came back and tried to negotiate better filtration, more fresh air in the system, and also setback zones, keeping smokers at greater distance from the tables where people were concerned. So this is again a graph that shows the no smoking areas are those yellow squares. There's a red line that shows what the national ambient air quality standard is for people outside for air. And we have some sample points that represent, this is a 3-day sample period, and these are the mean samples for those areas. So we did negotiate setback zones for this area in another round of contract language. The yellow zone is what the management proposed. The UAW proposed adding that red square. And again, we increased filtration, increased fresh air, and we did see significant reductions. So this is an example from 2014 where the smoke levels in pit 10 are 15 to 27 micrograms per cubic meter. So just one of the significant lessons we've learned from COVID, we in 2020, this is another graph. Now the smoke levels are back up. We did away with the no smoking zone and allowed smokers again to congregate in those areas, the slot machines around pit 10. And you can see we're back up to 110 to 136 micrograms per cubic meter. So this is really a take-home lesson in the limits of ventilation. So theoretically, the ventilation's the same, filtration's the same, fresh air is the same, but we've allowed smokers to congregate around those tables, and the levels of exposure have gone up for people that are going to be dealing in that pit 10 area. We have a data from 2021 and at the beginning of the pandemic that shows smoke levels are in the single digits when no smoking is allowed. So the levels are so low that we're picking up carpet dust or Dunkin' Donuts grease infiltrating from different areas. So with that, I'll stop my remarks, and I'm limited to 3 minutes, and happy to entertain any questions about sampling methods or contract language. Thank you.
Thank you, Andy. And we will move next to Dave Sherman, who is a Foxwoods dealer, a member of UAW Local 2121.
Good morning. I would like to thank the co-chairs for
Before
this opportunity.
you start, Dave, Andy, can you return your screen? Thank you. Go ahead, Dave.
Okay. I would like to thank the co-chairs for this opportunity to speak today. My name is David Sherman. I'm a dealer at Foxwoods for 25 years. I also serve as the co-chair for the Joint Health and Safety Committee at Foxwoods, and I am a local union discussion leader for the UAW International that focuses on health and safety. I am here today to discuss my experience in our fight against secondhand smoke exposures. It is well known fact that secondhand smoke increases the risk of cancer, heart and lung disease, as well as many other diseases. I have known many co-workers and other workers in other departments that had these horrible diseases while working at Foxwoods. As a result, many have lost their job due to absenteeism dealing with their disease, and others have paid the ultimate price and have died. Through contract negotiations, we have gained air quality testing. We have used extreme specific air sampling methods with mutual agreed upon vendor. Prior to the language being negotiated, the testing provided was not accurate and it was only done in the low populated times of the casino. I have participated in these test periods and have reviewed the data collected over the years. The data collected has shown little can be done through engineering controls to control the smoke in a casino. The UAW was forced to negotiate a smoke-free gaming area that gives preference to our sickest workers to work in, to protect them. This is a no protection offer to workers until they succumb to their effects of secondhand smoke. Unfortunately, Over the years, testing has shown that even smoke-free gaming areas, there are dangerous levels of tobacco smoke. We have been able to eliminate the risk of workers. Our efforts have not solved the problem. The gain we have made in collective bargaining has not been made throughout opposition from Foxford. Even though we have had testing since 2011, the union must fight to receive information and to this data. And to this date, we are still waiting for over a year's worth of maintenance records and CO2 damper reports, etc. These reports are supposed to be given monthly. Collective bargaining is not enough. We have participated, particularly the good ventilation system at Foxwoods has given the best ventilation system. We are exposed to toxic secondhand smoke. We are only workers that are not protected in the state of Connecticut. The other day, I was having a conversation with dealers about how much better the quality of air is at Foxwoods with no smoke being allowed. I was explaining the last 2 air quality reports and how the air quality has improved greatly since smoking has been banned. They commented how much better they feel overall. They come to explain how much better their jobs have been since the reopening smoke-free. Workers are not only want to be permanent for a ban, but they need it. Another dealer mentioned she hates smoke being blown in her face, does not want to return to smoking in a casino. Further, dealers are given numerous positive comments from patrons that Foxwoods is smoke-free. Just yesterday, I was given compliments from more than one patron how they enjoyed casino smoke-free environment. Now it's time to protect casino workers in the state of Connecticut. Many workers have heard me use the analogy of air quality in a casino when you work in smoke is like being downwind of a forest fire. Casino workers do not want to feel like that they are working in smoke. They don't deserve it. Please do the right thing. Ban smoke forever. Thank you very much.
Thank you, Dave. Next up, we have Heather Seinberg, a Foxwoods dealer, UAW Local 2121. Good morning, Heather.
Good morning. Thank you for allowing me to speak today. My name is Heather Seinberg. I'm a over 17-year employee of Foxwoods Casino. I'm an assistant floor supervisor in the table games department, which basically means that I'm a dealer some days in the week and the rest of the week I also supervise. I hold a position on the union and the employer's Joint Health and Safety Committee. I'm a union steward and I'm a proud Native American as well. I'm 42 years old and a mother of 4 beautiful kids. I have been diagnosed with asthma for many years now, but most recently I've also been diagnosed with emphysema. I struggle to breathe in every single day. There are days I can't walk and talk at the same time without having to stop and pause and take a breath or use my inhaler. Other days I'm okay, and I never know what kind of day I'm going to wake up to, unfortunately. If Foxwoods were to allow smoking on the gaming floor again, I would have to choose between my health and my career. I would have to choose between living a longer life with my family and being able to provide for them now. If I had to endure smoke being blown in my face for 8 hours a night again, I don't think I could make it a month without needing extra oxygen. When you work as a dealer, you're an audience to cigarette and cigar smoke. We can have between 6 up to 16 players smoking at any given time within inches from our faces. We can't step away from the table. We can't ask players to put it out. We're trapped while poison is blown directly into our faces. The players are so close, I've actually been burned multiple times by players' cigarettes or cigars over the years because they stand so close to us. Prior to the COVID shutdown, I'd go home every night reeking of smoke. I wouldn't even hug my family and with my work clothes on. I would go home so run down, which I know is from my lungs having to work 10 times harder to breathe. Since we reopened from the COVID shutdown, it's been like working in a completely different place. My eyes don't burn in water from all the smoke. I don't cough from breathing in someone's cigar. I don't have to go home and immediately shower and change just to get the smell of smoke off of me before I say hello to my kids. Foxwoods is cleaner. It smells cleaner in the building, and the constant cleaning of the property is actually starting to remove the yellow off of every surface in the building. Players are constantly commenting on how happy they are that we are smoke-free. And some I've even gotten to know as they've come for the first time ever because they're happy they can come into a smoke-free environment. The casino going smoke-free has helped our business grow, from what I can say. Over the years, I've known many of my coworkers who have died from diseases caused by smoking and secondhand smoke, and there's just too many to count. I've watched many of my coworkers struggle to quit smoking because we are constantly surrounded by it. Trying to quit smoking while working on the casino floor is the same as an alcoholic working as a bartender. The legislature passed the law in the state of Connecticut to protect all workers from the toxic, life-threatening effects of tobacco smoke. And you left thousands of us behind. I really enjoy what I do. I've built a career and I shouldn't have to choose between my job and my health. No employee should have to, but especially not casino employees. We work in Connecticut too, and we're being left behind. Thank you for allowing me to speak.
Thank you, Heather, and I do hope that your health improves, and we'll be thinking of you. And
thank you.
Next up, we have James Rapace from Rapace Associates Incorporated, a secondhand smoke, who are secondhand smoke consultants. James, good morning.
Mute.
Hi. There you go.
And I'd like to share my screen, if I may. Let's see.
Devin, does he have that ability to share a screen?
Yes, I do. Let me go down here, share screen. Here we go. Are we up?
You are.
Okay, that's terrific. Let's see if we can go to full screen. Okay. And let's see how we can get this to go full screen to view. This is it, I think. Okay. Well, anyhow, my name is James Rapace. I'm a secondhand smoke consultant. I've published 66 peer-reviewed papers on secondhand smoke. And I've been an expert witness in 4 lawsuits by casino workers against management in 4 casinos over injuries sustained from secondhand smoke. My bottom line opinion is that secondhand smoke is a clear and present danger to casino workers. And I know this because I've published a paper here in environmental research on 66 casinos, on 3 casinos in Pennsylvania, and 36 Indian casinos in California. In addition, I published a book on waging the war against secondhand smoke, which details my career over the past 45 years dealing with secondhand smoke. Now, secondhand smoke is a hazardous air pollutant. It contains 172 toxic substances, 67 known carcinogens, 47 hazardous wastes, 33 hazardous air pollutants, and 3 criteria air pollutants, including fine particulate matter. And non-smokers inhale and absorb this pollution in smoky casinos. You can actually measure the penetration of secondhand smoke in their blood, urine, and saliva, and I have done that. Now, there is no question that secondhand smoke is hazardous, and since 1986, public health, occupational health, and environmental health authorities have condemned secondhand smoke as a cause of lung disease, cancer, and heart disease. The basic issue is that employers have a moral obligation to operate a safe and healthy workplace. And frankly, in casinos which allow smoking, that this is not a safe and it is not a healthy workplace. Secondhand smoke harms casino workers. Let's take a look at some of the cases that I've been involved in. Mullen versus Treasure Chest Casino in New Orleans, 1998. 3 casino workers were carried out on stretchers with acute onset asthma and were hospitalized. 150 other workers were treated for respiratory effects. This lawsuit was settled for between $1 and $2 million. Most casino workers do not have the option of suing their employers, but on casino riverboats, which are governed by the Jones Act, they're treated as seamen, and under the act, they have the right to sue their employers. Empress Horseshoe Casino in Hammond, Indiana, sailing out on Lake Michigan. 23 casino workers were injured from secondhand smoke, 19 with respiratory effects, 1 developed heart disease, 1 developed cancer, and the captain died. This settled for between $10 and $20 million. Tropicana pit boss, Vince Rennick, got into an automobile accident after 25 years of working at this casino in Atlantic City in the Tropicana. And when he was taken to the hospital and got a chest x-ray, they found a spot on his lung. It turns out he had contracted lung cancer from working in the casino. That case was settled for $4.5 million. Vince was one of my clients, and he is now working in a smoke-free casino in Delaware. NIOSH, the National Institute of Occupational Safety and Health, studied 3 Vegas casinos, Bally's, Paris, and Caesars, after workers complained that secondhand smoke exposure was sickening them. This was in 2011. NIOSH measured biomarkers for secondhand smoke in the urine of the non-smoking casino workers who were exposed at work only. They found a potent tobacco-specific lung carcinogen, NNK, in their urine. NIOSH also reported that 24% of casino dealers had symptoms suggested of work-related asthma. That sounds very familiar, doesn't it? NIOSH then recommended that casinos ban smoking. I have estimated that of the 550,000 or so casino workers in this country, in both commercial and Indian casinos, that there are approximately 342 deaths per year from secondhand smoke exposure. Let's take a look at the claims that secondhand smoke can be controlled by ventilation. This is the American Society of Heating, Refrigeration, and Air Conditioning Engineers, ASHRAE, position document on environmental tobacco smoke. This is 2020. This was just issued. And they have been issuing these position documents since 2003. Here's the bottom line. Even when all practical means of separation and isolation of smoking areas are employed, adverse health effects from exposure in non-smoking spaces in the same building cannot be eliminated. Neither dilution ventilation, air distribution, nor air cleaning should be relied upon to control secondhand smoke exposure. That's what the ventilation professionals are telling us. Ventilation, air cleaning doesn't work. Now, let's take a look at some of the measurements that I've made with concealed real-time air monitors for secondhand smoke. And I have reviewed the data, not only that I've taken, but other people have taken in 94 casinos, including 37 Indian casinos. And this is the Cal Neva casino in Reno. And this was in 2010. These are some of the monitors that I have concealed in a camera bag. This is a carcinogen monitor. There's a fine particle monitor under here. This one measures environmental temperatures and relative humidity. This measures carbon monoxide and carbon dioxide as an index of ventilation. And here's the best ventilated casino right here, the Atlantis. It had 45 liters per second per person. And you can see this is the smoking area, the non-smoking area, which was contaminated, and this is outdoors. Regardless of the ventilation, you can see the pattern repeats. High levels of secondhand smoke in the smoking area. The non-smoking area was still contaminated, and outdoors, it was very, very low. Here's the Fernley Nugget, which is the only smoke-free casino in Nevada. And you can see there was no difference in these gaming areas, in the non-smoking areas, which were adjacent and outdoors. And those levels were extremely low. And all casinos met or exceeded the old ASHRAE standard of 15 liters per second per person. Let's take a look at the 36 California Indian casinos. Here's the levels in the smoking slots. They were running about 63 micrograms per cubic meter. Non-smoking restaurants were contaminated, running about 29-30 micrograms per cubic meter. Outdoors was about 6 or 7 micrograms per cubic meter. I measured in the Delaware Park Casino just before and after Delaware went smoke-free in 2003. This was before the smoking ban. Levels were running well over 200 micrograms per cubic meter. After the smoking ban, fine particle pollution dropped 95% to outdoor background levels. Carcinogen levels were running about over 160 nanograms per cubic meter. And after the smoking ban, the carcinogen levels in the air decreased by 95%. Let's take a look at the data that was collected by Roswell Park Cancer Institute in Foxwoods and Mohegan Sun in 2008. Here again, Foxwoods levels were 77 micrograms per cubic meter in the smoking area, 45 in the non-smoking area. Mohegan Sun, 74 in the smoking area, 54 in the non-smoking area, and less than 11 micrograms per cubic meter in the outdoor air. And the EPA National Ambient Air Quality Standard for clean air on an annual basis is 15 micrograms per cubic meter. Now let's take a look at all the data that was ever collected by measurements of secondhand smoke in casinos. And this is the fine particle concentration in micrograms per cubic meter on the vertical axis from 1 to 1,000 micrograms per cubic meter. And these colored bars here show what the air quality is: good, moderate, unhealthy, unhealthy for sensitive groups, unhealthy, very unhealthy, hazardous, and significant harm. And you can see some of the casinos were way up in the hazardous area. Foxwoods and Mohegan Sun were right here in the unhealthy area. You can see these are the levels in the outdoor air, considerably lower. Foxwoods and Mohegan Sun were actually worse than most. And as Dave Kamai or Andy Kamai has shown, levels in the non-smoking areas were considerable in the, even in the non-smoking pits, and in the smoking areas were very, very high. This is the levels in the average overall. Ventilation and air cleaning were used, and the levels were 61 micrograms per cubic meter in 88 smoking casinos. In the 3 smoke-free casinos where we have data, they were average 3.1 micrograms per cubic meter. And you can see the non-smoking casino restaurants were contaminated, and the levels here were even lower than in the outdoor air. So the conclusions: casino smoking creates serious air quality levels. Oh, I want to make one more point on this. These are the air quality standards for fine particles, but secondhand smoke is actually more toxic and more irritating than fine particles. The level of median level of irritation is 4.4 micrograms per cubic meter. So this is where the average non-smoker will begin to get serious irritation, eye, nose, and throat irritation from secondhand smoke. And the malodor threshold is 1 microgram per cubic meter. So you can see it's very polluted. Anyhow, unseparated non-smoking areas are polluted by secondhand smoke. Ventilation and air cleaning fail to control secondhand smoke in casinos. Patrons are at increased risk of heart attack from secondhand smoke after 2 hours. And I mentioned that overall, several hundred casino workers are dying from secondhand smoke each year. And I conclude with 10 reasons why Foxwoods and Mohegan Sun should reopen smoke-free. Secondhand smoke injures workers' health. There is no doubt about that. It increases the risk of cancer, heart disease, and lung disease. The levels that have been measured in the 2 Connecticut Indian casinos are very high. Ventilation and air cleaning cannot control secondhand smoke, according to the Authority on Ventilation. Non-smoking areas contiguous to smoking areas are polluted, and the Connecticut casinos, the 2 of them, exceed the irritation median by 17-fold and the median for malodor by 76-fold. As has been mentioned before, 4 out of 5 casino patrons do not smoke. 22 states and territories mandate 100% smoke-free gambling. And more non-smokers in Massachusetts avoided smoking bars and restaurants in the old smoking days than there were smokers in the state. And what does that tell you? You can make a buck if you are a non-smoking casino, and all of these states that are here in powder blue do exactly that. So I'd be happy to answer any questions. There's a more detailed presentation that I have submitted in background to the committee. So I'll be happy to answer any questions that you may have.
Thank you, Mr. Pace. And we will have questions after our last presenter. So if you will kindly stop sharing your screen.
Okay.
And we will.
Let's see. Stop share. There we go.
Thank you very much. And if you will mute your microphone as well. Thank you. Our final presenter is Michael J. Wishney, William O. Douglas Clinical Professor of Law from the Yale Law School. Professor Wishney. I saw him before, I believe. There you are.
Yes, I'm here.
Your screen is a little tilted, so we can't see your face.
Sorry about that. I was just disconnected and reconnected. How's that?
That's great. Thank you. Go ahead and begin.
Okay. Thank you very much, Chairs Kushner, Porter, Abrams, and Steinberg. It's a pleasure to be with you today and all the members of the committee. My name is Michael Wishney. I am, as was heard, the William O. Douglas Clinical Professor of Law at Yale Law School, where I co-teach the Worker and Immigrant Rights Advocacy Clinic, the Veterans Legal Services Clinic, and the Peter Gruber Rule of Law Clinic. More than 10 years ago, my students and I, over the course of several semesters, represented the UAW during its effort to organize casino workers in Connecticut. I have not represented the UAW since then, and I appear today in my personal capacity. Most of the testimony so far has gone to the question of whether the legislature should extend the smoking ban in the state to the tribal casinos and close the loophole that was created in 2003. I'm going to speak to a much narrower point, which is the question of whether the legislature has the authority to do so if it chooses. And I'm going to make 2 points on that. Before I do, I'll preview the bottom line, which is yes, in my view, the legislature has the full authority, should it choose to exercise it, to extend the smoking ban to the casinos. As many of you are aware, this question arose previously when leaders of the legislature asked then Attorney General Richard Blumenthal for an opinion. And in 2008, Attorney General Blumenthal concluded that to extend the smoking ban would be a lawful exercise of state authority and would be entirely compatible with the compacts between the state and the tribal nations. In 2008, Attorney General Blumenthal went on to conclude that a smoking ban could be enforced in either of 2 ways, either as an injunctive action under the compact or, if necessary, indirectly, by suspension or revocation of a casino's liquor permit if it failed to abide by an extended smoking ban. I believe the Attorney General's legal analysis is sound and that his conclusions were correct in 2008 and that they remain correct today. As a result, in my view, the General Assembly has the authority, should it choose to exercise it, to repeal the exception to the state smoking ban for casinos with casino liquor permits. I believe a decision by the legislature to close the loophole would likely be upheld by the courts for reasons set forth by the Attorney General in 2008. So let me speak briefly to the reasoning in then Attorney General Blumenthal's opinion in 2008. So as you know, both the Mohegan and the Mashantucket Pequot tribes are parties to gaming compacts with the state of Connecticut. Technically, as Attorney General Blumenthal noted, one is a gaming compact and the other was done under federal procedures, but that doesn't make a legal difference. And the language in the two compacts, the relevant language, is identical. In section 14A of both compacts, the tribes and the state agreed that, and now I'm going to quote, tribal ordinances and regulations governing health and safety standards applicable to the gaming facilities shall be no less rigorous than standards generally imposed by the laws and regulations of the state relating to public facilities with regard to building, sanitary, and health standards and fire safety. What that means is that the state and the tribes agreed that when the state adjusts its health and safety standards, making those relating to public facilities with regard to building, sanitary, health standards, and fire safety more rigorous, then the tribes under the compacts agreed to do the same. That is to adjust tribal laws to conform to the state's more rigorous standards. In 2003, the legislature implemented a statewide smoking ban, and at that time chose to exempt the casinos with casino liquor permits. In my view, it was not required to do so, but it did so at the time. Should the legislature now decide to close that loophole, under the compact, the tribes will be obliged to revise their own standards and regulations to conform, as they agreed to do when each negotiated its compact. The provision in section 14A for harmonizing tribal health and safety standards for public facilities is not a broad exception. And in my view, the state may not rely on it to justify unrelated incursions on tribal sovereignty. But a smoking ban is without question in the heartland of the sort of health and safety standards for public facilities contemplated by the agreements. This is what the Attorney General concluded in 2003 as well, when he wrote that a smoking ban legislation involves an obvious and important health issue and therefore implicates application of section 14 of the compacts. And he repeated that in 2008, when in his opinion, he explained that the statutory smoking ban is clearly and quintessentially a public health protection, applying broadly to all public buildings and facilities across the state. Again, what this means is that the state legislature may not abuse this authority. It may not pretend that something is a health and safety standard when it's not, but a smoking ban is clearly at the heart of state public health measures. And there's no question that it could be enforced and must be enforced via the terms of the compact. In addition, in section 14B of the compacts, the very next provision, the tribes consented to abide by state liquor law. As a result, casinos in Connecticut, even if on tribal land, need to receive a liquor license from the state in order to serve alcoholic beverages. If Connecticut liquor laws were revised to ban smoking as a condition of holding a liquor license, and that is the vehicle for the smoking ban in current statutes, then that would also be a mandatory provision under the different term, section 14B of the compacts. And then finally, in 2008, the Attorney General was asked, well, if the legislature did extend the smoking ban, how might it be enforced? And he answered at the time through two ways. First, section 13 of the compacts provides that the state may sue in federal court for an injunction to ensure compliance with the compacts. Second, alternatively, the state could take steps to suspend or revoke a liquor license if the tribes failed to comply with the statewide smoking ban. So there would be two options for enforcement. Let me make one other point. Apart from the authority under the compact negotiated between the state and the tribes, which reserves to the state effectively the power to regulate health and safety conditions in public facilities by obliging the tribes to conform tribal laws to any more rigorous standards set by the state, there is a second and independent source of authority which the legislature could choose to exercise. Historically, federal law has recognized little or no tribal sovereignty in the domain of liquor regulation. In fact, for many years, federal law prohibited the sale of alcohol on tribal land. It was an absolute prohibition. And as some of the earlier testimony reflected, Congress has much broader authority here under its plenary powers than states do. In 1953, however, Congress relaxed the absolute prohibition on sale of alcohol when it enacted a statute now codified at Title 18, Section 1161, which permitted the sale of alcohol on tribal lands, provided it was done consistent with tribal law and with state law. In other words, in 1953, Congress eliminated the outright ban on alcohol sales, but said that going forward, alcohol sales could be done only if it was consistent with tribal and state law. As a result, states have the authority to regulate alcohol sales on tribal lands. In 1983, in a Supreme Court case called Rice v. Rayner, Justice O'Connor, who was mentioned earlier, explained for the court that Congress has divested Indians of any inherent power to regulate the use and distribution of alcohol beverages on tribal lands, but it has granted the authority to do so, provided it is consistent with state law. In our state, in Connecticut, this principle has been applied. In 2007, for instance, Judge Arterton of our federal court, she sits in New Haven in the court there, relied on Rice v. Rayner for the proposition that the state of Connecticut can enforce its minimum drinking age on tribal land in a case called Van Krunigen against Plan B. As a result, even without the compacts and even without the tribe's agreement in Section 14A, that tribal health and safety standards will be no less rigorous for public facilities than statewide standards, the legislature could choose to exercise its authority over liquor control by conditioning permits on a smoking ban. Again, to be sure, a state cannot abuse its authority over liquor by imposing all manner of conditions. And there are some cases, there's a case out of South Dakota that's gone up and down the course in the last few years, in which there's been a challenge to whether the state had layered on conditions to its liquor license beyond what was reasonably necessary for liquor control. But here too, that does not seem to be the issue. The clear language of the compacts negotiated between the state and the tribes reserves to the state the authority to legislate for health and safety and obliges the tribes to conform to standards as rigorous as those of the state. I'm not speaking today to whether the legislature should exercise that authority, but in my view, it's not a close call as to whether that authority exists. I believe Attorney General Blumenthal was correct, and that if the legislature chose to act, the courts would uphold it. It was notable to me that in the earlier testimony, I didn't hear either attorney for the tribal nations dispute the authority of the legislature to act. And if it chooses to do so, I do think the courts will uphold it. Thank you very much.
Thank you, Professor Wishney. And so we have concluded the panelist testimony, and now we will take questions from the committee. And I would urge committee members to be very brief in asking your questions so that we can get as many questions and get through as many members of the panel as possible. And I would ask that you raise your hands on the under the participant code icon that allows for hands to be raised. And we will, if we get through all of the first round of questions, then we will afford committee members the opportunity to ask a second question. And as of yet, I see no hands. So I have
my hand's raised, Senator Kushner. Yes, I was just going to let you know that Representative Zupkis does have her hand raised.
Oh, okay. It didn't show up on my, I believe you, but it didn't show up here. So, Representative Zupkis.
Thank you, Madam Chair, and thank you, Representative Porter. I just have, I guess, two quick questions, and one is to one of our, I guess, a union rep, and the other one would be to the tribal attorney. So my first question is, has the union...
Zupkis, would you, I'm sorry, but I did explain that if you could just ask one question, we'll try and get around to the second. So pick your one you want to ask first, and then if we have time, we'll
okay, well, I guess they kind of relate, because my big question is this, does the legislature have the authority to enforce this onto the tribes or create a law to do this? I heard the last attorney, Mr. William, talking about you could pull their liquor permits and all that kind of stuff. That aside, because that's a whole different issue. does the legislature have the authority to create a law to ban smoking on tribal land?
Thank you. And I would address that to Attorney Wishney, and I will recognize any of the other panelists who might want to respond to that.
Yes, the answer is yes, leaving the liquor licenses aside. Under Section 14A of the compacts negotiated between the tribes and the state, the tribal nations agreed that their health and safety standards for public facilities would be no less rigorous than those adopted by the state.
I'd like to respond to that if I could.
Yes,
Kane.
please.
So one has to be careful about such a broad sweeping statement because the state law does not directly apply. So don't assume that to be the case. The issue would be whether the Mashantucket Pequot Tribal Nation, with respect to the clause being cited, has enacted standards that meet, in our view, meet or exceed those of the state of Connecticut, standards for indoor air quality. Don't assume immediately that an all-out ban would do the trick by Connecticut enacting that law. And when I say do the trick, there's this kind of notion behind this whole proposition that the Indians can't be trusted. That is an historic, stereotyped view. And what we're dealing with here is a diplomatic relation between nations. And the presumption to simply impose this upon the Mashantucket Pequot Tribal Nation is frankly anathema to the cooperative sovereign relationship that has marked the Pequots and the Mohegans with Connecticut for decades. So I think one has to think about this at large, with an attitude at large and in context. It's not simple. If Connecticut enacts an all-out ban on smoking, there will be significant issues about whether the tribe's procedures exceed or meet the state's procedures, and likely some debates about whether the standards have been met. What are those standards? Those standards, they're not defined by an all-out ban. They have to be particular standards for indoor air quality. This isn't to say that the Mashantucket Pequot Tribal Nation isn't concerned about health and safety of their workers. There is a collective bargaining process in place. If the terms and conditions of a collective bargaining agreement are breached, an unfair labor practice charge can be brought. I heard some complaint that there were reports that are supposed to be made available and they haven't been made available under the collective bargaining agreement. An action for an unfair labor practice charge can be brought if that's the case. In any event, standing back from all of this, this is a time where there's more of a commitment to equity principles, righting the wrongs of the past. And the fact that this body didn't see fit to provide a land acknowledgement out of the gate when it's ubiquitous across the country for public forums to provide land acknowledgements, and to leave that to the only indigenous leader in the group shows that there's an attitude that needs to be fixed. And we need to be very careful about the diplomatic relationships that are at stake in a presumption that you can simply do the trick, so to speak, by enacting a law here. And I'm sorry if I sound like I'm defensive here, but history shows that this kind of top-down approach to quote unquote Indian problems, as if they can't be trusted, has proven problematic.
Well, thank you for both of your answers. I've always been under the impression that being on sovereign land, you have your own laws, and we have to, understanding the compact, I was ranking on the Public Safety Committee and went through, so I understand a little bit about this, but thank you both, and I would hope that it could be negotiated through the unions and everybody work together through that aspect versus law. But thank you so much. Thank you, Madam Chair.
Thank you, Representative Zupkus. And I would like to, just to make sure that if anyone's listening at home, I do want to clarify, and I know Attorney Smith, you were not saying this, but I do want to clarify that no one that I've ever heard in this legislature has ever made a statement that you cannot trust Indians. And I do recognize there was a land grab, and I think some of us, most of us, feel that that was wrong at the time, and it should be addressed today. However, I do want to point out that I have never heard anyone in this legislature on either of these committees disrespect the tribes in the way that you suggested some might. And so I just want to be careful that anyone might have that misunderstanding, because I know that's not the case. We're here today to address whether or not the state has the authority under the compacts and under federal law to ban smoking in the casinos, and whether or not that's the right thing to do. So those are the only questions that we are addressing here today. Having said that, I had difficulty. I couldn't see Representative Zupkis's hand. So if anyone else has a hand raised, please let me know. I see Representative Rutigliano.
Thank you, Madam Chair. I can't find my reaction thing to wave my hand, so I apologize. And I think the last speaker prior to the attorney that just spoke may have answered my question, but I was pulling into the garage and it was coming in and out. I was curious to know why are the casinos obligated to follow state Connecticut liquor law? Because if they are sovereign, why do they? But I heard a partial answer from the gentleman that was speaking, but not the full answer. If you could encapsulate that, it was something I've always been curious about.
Well, let me first ask if Attorney Smith would like to respond to that, and then I will ask the professor who made that statement. Attorney Smith, would you care to respond to that?
Sure, I'd be delighted. Again, what I was trying to say is that state law does not automatically apply. It has to go through the filter, if you will, of the procedures that are in place. That is the procedures that govern gaming under the federal law of the Indian Gaming Regulatory Act. Class 3 gaming, also just casino style gaming, can proceed as a matter of federal law only through either a compact or procedures. And the procedures at issue, the Mohegan tribe has a compact, the Mashantucket Pequot tribal nation has procedures. The procedures are essentially enacted by the Secretary of the Interior. Compacts are bargained for and are an agreement between the tribe and the state. In any event, the compact for Mohegan and the procedures for Mashantucket state that tribal ordinances and regulations governing health and safety standards applicable to the gaming facilities shall be no less rigorous than standards generally imposed by the laws and regulations of the state relating to public facilities with regard to building, sanitary, and health standards and fire safety. So that means that the tribe must meet or exceed state standards. It doesn't, as I say, it has to go through the filter, if you will, the procedures. State law doesn't automatically apply. One has to see whether the tribe's standards meet or exceed those of the state. And the standards that are at issue here would be standards for indoor air quality, and an all-out ban doesn't set standards. I mean, now we're into confrontation mode. I mean, how would the tribe respond? Is this automatically, quote unquote, enforceable? We're now in a conflict mode between sovereigns where we really would hope not to be. But since you've asked, then we would tell you that the flat out broad statement that somehow these automatically are imposed is not particularly accurate once you are in a confrontational situation and putting the tribe on the defensive. Because
pardon me, Attorney Smith, I haven't asked. I was just curious if the following of the liquor laws is voluntary through agreement, or are you subject to the liquor laws of the state of Connecticut? It's just, I'm just curious.
Oh, I'm sorry.
The nation is sovereign, and if it felt like it could do as it chooses, or if they voluntarily agreed with the state on liquor laws or not.
Oh, I'm sorry, Representative.
It's quite all right.
I misunderstood. I thought you were talking about the broader issue of health and safety standards, not liquor in particular.
No,
I apologize.
No, I must admit that I'm a patron of the casinos, as most of the people. I go up there for many different things over the years, and I had always found it curious that I know that they're sovereign, but yet they follow certain things and they don't follow certain things, or they have their own things. So I just was curious to how that came about.
I appreciate
I'm sorry to
that.
take a lot of time on the question, but I think it's relevant, and on whether or not the state can come in and do other things.
Right. So what
Representative Tigliano, I think your question is germane to the topic, and I would just ask that we all be brief in asking our questions. Go ahead, Attorney Smith.
I'm sorry, I think that we're referring to a separate section of the procedures, which is 14B. I was citing to the general health and safety standards. 14B of the compacts conditions the permits of liquor license on compliance with, quote, laws and regulations of the state applicable to sale or distribution of alcoholic beverages. And whether those encompass public safety issues is an open question. I think the more direct section of the procedures / compacts is the one that I cited to you, quoted to you 5 minutes ago.
Madam Chair, could I have a quick follow-up?
Hold on a second, Representative Tigliano, because originally you did ask that question of the attorney who made the statement. So I'll ask Attorney Wishney if you'd like to also respond.
Sure, just briefly. Liquor control is a bit different. It is an area that historically Congress did not recognize tribal sovereignty over. And so Congress has exercised its plenary power in fairly dramatic ways. When it relaxed that power somewhat, not fully respecting tribal sovereignty, but relaxing that power somewhat in 1953, it did allow for the sale of alcohol on tribal lands, subject to both tribal law and state law. So the short answer is yes, Connecticut state liquor laws do apply on tribal lands in Connecticut as a function of federal law, independent of the compacts. It is also reflected in Section 14B, as was just said, of the compacts, but even without the compacts, state liquor law would still apply.
Thank you. And Representative Tigliano, if you could just hold your follow-up, because I've just cut off Representative Zupkus from doing that. I don't want to be unfair. So I would see if there are any other hands up at this time. If you have a question, yes, Jillian, go ahead. The function isn't working otherwise, so just raise your hand in the future. Jillian, Representative Gilchrist.
Thank you, Senator. Yeah, I couldn't find my button. My question has to do, and I might be getting the number wrong, but of the 22 casinos, I believe that's what was said, that have banned smoking, how many are associated with tribes? And then how many have banned it because of a state law?
And I will ask if any of our panelists have that information, would like to respond.
Julie, Senator Kushner, I was the one that said that. I don't know the answer to that, Representative Gilchrist, but we can certainly get that to you.
I do actually have some research that was done for me on that issue. So I can tell you from the research I received by state, in Michigan, 14 tribal casinos are non-smoking. In California, 25 tribal casinos are non-smoking. In Arizona, 12. In New York, 10. In Washington, 11. And in Wisconsin, 19. Now, I will say that there may be some problems here with the data, because recently a number of tribal casinos went non-smoking as a result of COVID, recognizing how dangerous smoke was, particularly during this health crisis. So, but we can get you further data on that, and I'll make sure that we get it to the clerk and every committee member gets it. Any other questions? I have a question before we move on. I think that this question goes to the union, and in appreciation for what has been said by both tribes and recognizing the collective bargaining relationship, I do want to ask about whether or not, particularly I know in Foxwoods, you've been engaged, the union has been engaged in collective bargaining recently, and I want to know if there's been any effort to engage, to reach an agreement with the tribes that voluntarily Foxwoods would continue, or that Mashantucket Pequots would continue the ban on smoking after the public health crisis has receded, and if so, what was their response?
I guess that would go to me, Senator Kushner. So we're currently in bargaining with the casinos for, I think, our third contract. We have not brought this. We actually have asked about banning cigars at the bargaining table, and that was not accepted. That was they didn't agree with that. But to answer your question, I had a very brief conversation with Chairman Butler expressing that we would be very willing and interested in having a discussion about continuing to ban the smoking post-pandemic. And Chairman Butler did seem open to that conversation and expressed that it would be some time before they thought they would go back to a smoking environment. So we would be open to that. However, I would, for those who don't know, you should know that we only have a collective bargaining agreement with the Foxwoods. So we would not have any jurisdiction to negotiate such provisions at Mohegan Sun, and that would be problematic, I think. So it really is incumbent on the state to enter into those negotiations or have those discussions. We would certainly be very supportive. There was agreement made back in 2010 or 11 between former Governor Rell. Some of you may have seen it. We have a comparison, and it really was a far, far cry from banning smoking. It required some signage, some non-smoking areas. The tribes could invest in better ventilation, testing and monitoring and employing accommodations, but it was very, very far short of what we're seeking to do in order to protect workers in this from secondhand smoke. So hopefully that answers the question. This has been an ongoing issue for a very long time. Let's just put it that way.
More than a decade, as I recall. I did see Dr. Pettit, Representative Pettit. I'm told you have. Oh, I see your hand now. You have your hand up. Thank you.
Thank you. I apologize. I was here in the first hour and then have been away at a press conference for the last half hour. As I've understood the discussion that I was able to hear, if we go forward as per Attorney Wishney's assessment, I would ask Mr. Attorney Smith, would the nation or the nations view this as an affront to their sovereignty? The initial discussion, it seemed like this would be an issue in terms of sovereignty. I wonder if I could hear your answer to that. Thank you.
Attorney Smith, the procedures, you have to wait for me to call on you, but go ahead.
My apologies, Senator Kushner.
No, people do it to me all the time.
All due respect. Thank you for the question, Representative Pettit. Yes, I think in a word, as we've discussed at the get-go, the tools that are readily at hand here are diplomacy, a respectful sovereign-to-sovereign discussion, as happened in 2008, 2009, which led to an agreement when then Governor Rell was in office. And the other tool, at least for Mashantucket, is the collective bargaining process, which is, meant to abide by the laws of the Mashantucket Pequot Nation that give bargaining rights to employees. And I'll just say it's pretty unusual for a tribe to enact a public sector labor law. And the Pequot decided to do that. There are a lot of tribes that fight labor laws. The Pequots, as you may know, OSHA applies to the Indian country at Mashantucket, and the tribe has enacted its own TOSHA, its tribal occupational safety and health law, and it has collective bargaining. So we feel like those are attributes of sovereignty in action, and would feel that if the state is trying to use a different approach by enacting its own law to sort of, you hear the words enforce, have jurisdiction, all of those words connote a sense of confrontation between sovereigns And that's just not the spirit that the nation would like to be in.
I appreciate that answer. Thank you very much. Thank you, Madam Chair.
Thank you, Representative Pettit. But I do want to ask if Attorney Wishney would want to add anything to that.
No, I think that the question went more to how the legislature should proceed, not whether it may proceed. And my remarks were really directed to whether it has the option to proceed. If it chooses not, whether it should exercise that option or how.
Thank you very much. Any other questions? And I will ask Devin if you, I can then, Devin, are any other hands raised?
Madam Chair, no hands are raised at this time.
Okay, then I will go back to Representative Zupkus. Did you want to ask your second question?
Thank you, Madam Chair. I mean, my only other question was, has there been any meeting negotiation set up between the union and the tribe to try to work this out?
Who from the union would like to answer that?
No, like I said, we have tried to have this discussion on numerous occasions with the tribe, and in fact, had very big fights in this legislature over that. All I can say is that we are open to doing that, but we have not been able to get anywhere with that discussion.
Thank you, Beverly. So you're saying y'all have never sat down and talked about this at a table?
No, we have actually sat down at the bargaining table and actually have a number of provisions in the contract around air quality and testing and monitoring. We have never been successful at getting a full ban through the collective bargaining process, but certainly we have discussed this often.
So you've discussed it, you haven't gotten it banned, and they haven't banned it. That's the problem.
Yes, and I would ask Dave Sherman to respond also, because he's at the bargaining table. Dave, go ahead.
At previous negotiations, we have asked for a total ban of smoking, and well, we asked for no smoking. It wasn't even a ban back then. The word ban didn't come up. Basically, we asked for no smoking. We have yet been able to negotiate anything close to that. They have not entered into any serious negotiations regarding that. We've only made progress in ventilation systems.
Okay, thank you. I was just curious if that had started. Thank you.
And I know, related to your question, Representative Zupkus, it might be helpful, Dave, if you could tell us, if you can, what percentage of the tables you've been successful in getting non-smoking in the casino. You've had some bargaining over that, as was explained by your charts, or Andy's charts, I believe.
Yes, we have the Rainmaker, which is called Pit 3 room, which is non-smoking, which is currently closed due to the pandemic. The casino is not reopening, but that was our non-smoking pit, which we have negotiated, where dealers can opt to work in there. But yeah. I can say at both casinos, they do have a non-smoking area, but there's more dealers that are asking to get into those pits due to health conditions that they're spots for.
Right. So, I mean, I could understand that, but so you have gotten somewhere. So it's what is the give and take? And right, I get it. Thank you.
Thank you. Other hands. Maybe we'll go back to Representative Bertigliano. You had a follow-up. I think we may, I know people are getting ready to go into session. We have about 10 minutes left. I will ask, just on that same subject, just to maybe Andy Comite could also comment on, to what extent, I think you had slides and so did the consultant, James Rapace, about even where you have a non-smoking area of a casino, does that really reduce the impact of secondhand smoke on either those dealers in that section, or does it bring it down throughout the casino?
I believe the Rainmaker that's been designated no smoking has a separate ventilation system. where you have historically the poker room has been, part of or contiguous with a smoking area. And so you have this two ways that smoke gets into those no smoking areas. You just have drift, so the smoke wanders. And then you have recirculation where you have inadequate filters, not enough fresh air, and the particulate gets through the filters and gets distributed. So that's historically with the poker room. So the slides that I showed no smoking areas with still 70 micron, a mean of 70 micrograms per cubic meter. Those were from the poker room specifically. There hasn't been any air sampling since the Rainmaker's been designated no smoking. There's also the definition of no smoking in some of the studies could be, say at the MGM casino, if a dealer or if a table, maybe the table game patrons want a no smoking table, they can put up a no smoking sign on that table. And so that does, the dealer is still surrounded by other smoking tables, so that there's still this issue of drift and exposure. So that the idea of designating a no smoking table doesn't really solve the problem at all.
Thank you. And finally, I do have another question. I know, and this is for Attorney Wishney. One of the attorneys who testified this morning said, for the tribe, said that this would be a whittling away of sovereignty, and I wondered if you could address that comment, whether this has any, does this expand the state's reach as far as imposing on sovereignty with this?
Not in my view. It would act, given the existing relations, which are largely defined by federal law and the compacts, it would be a matter of the state acting within the zone that federal law and the compacts have allowed it to act in. I don't think it would expand or contract state authority or tribal sovereignty.
Thank you. And I'm sorry, I did not see that James Rapace had his hand up, and I don't see you on the screen. So would you like, oh, there you are. Thank you.
Yeah, I'd like to comment on the issue of indoor air quality standards. There is no indoor air quality standard for secondhand smoke. If you're talking about a hazardous air pollutant, it's just a question of what is the degree of risk, and is it less than, let's say, less than for occupational safety and health? Is it less than 1 in 1,000, which OSHA uses for significant risk of material damage to health? And when I was at OSHA when they proposed a regulation of secondhand smoke in workplaces, and they were ready to go ahead, not with an indoor air quality standard, but to simply ban smoking in workplaces. And unfortunately, after the hearing, which lasted about 16 months, back in 1993, 1994, the Congress put pressure on OSHA to table the rule, proposed rule, and they never did regulate it. I have looked into the issue of what is an acceptable level of exposure, and in no place where people are congregated in a public workplace where it is ventilated according to any ventilation code, even extra ventilation, you cannot get down to a level of risk that is below 1 in 1,000. It's not possible. You need a tornado-like level of ventilation to do that. So it is simply can't be done. And so it really is an issue of worker health. And since OSHA is not regulating it, and there is no indoor air quality standard, the only option at this point is to do what the airlines did. They had this very same arguments to all the flight attendants back in 1998 over the Oberstar Committee, the House Health and Aviation Subcommittee. And I testified at that hearing. And the risks for flight attendants which have much lower exposures, by the way, than casino workers do, were completely off the charts. So what carried the day was the testimony of the flight attendants, which convinced the House Aviation Subcommittee to vote for a 6-hour ban on smoking on airlines. And ultimately, the following November, the entire legislature, House and Senate, voted to ban smoking on everything but international flights. And now they're banned as well for a long time. So this is the same issue as for the flight attendants. You cannot have a safe and healthy workplace with smoking in it. Not possible.
Thank you. Any other hands? Devin, am I missing anybody?
Madam Chair, no, there are no more hands up.
Thank you. So with that, we have concluded the informational hearing, and I do want to say thank you to all of the participants here on the panel today. We appreciate your input. This is an issue that has been before us at the legislature before. I appreciate the attention of both committees to really look at this question. I have a great deal of respect for the tribes. My interactions were not limited to the Mashantucket Pequot tribe. I think everyone here knows that I did negotiate those collective bargaining agreements before coming to the legislature. But I also worked with both tribes in expanding gaming opportunities in Connecticut and with the Mohegan tribe in Massachusetts. And during that time, we developed a very good working relationship. So Attorney Smith, when you suggest that this might be contentious, I believe having worked with the tribes in the past, that we can find a way to reach common ground and protect all the workers and the public at our state's casinos, at the tribal casinos that are within our state. So thank you so much for participating today. And with this, I'll conclude, and you have 2 minutes to get into the House session. So we did this in record time, and I appreciate everyone's consideration to make that possible. Thank you very much for being here today. With that, we conclude this informational hearing.